Shall we start this morning's Radcliffe Chambers Junior program? My name is Andrew Brown. I'm a barrister at Radcliffe Chambers. I'm joined by my estimable colleague, Mr. Jonathan Edwards. Today we'll be touching on a few, oh yes, please do say hello, Jonathan.
Yes.
Sorry to
hello, everybody, again.
So today we'll be touching on a few interesting matters related to insolvency. In the shortest of introductions, I'll be speaking briefly about DLAs, dividends, directors' remuneration issues, and two recent cases from the High Court. Jonathan will be giving a much more interesting and insightful talk all about insolvent partnerships, which I'm actually very intrigued to listen to because they sometimes do my own head in. So with all of that being said, I'm going to take the scary step of trying to share my screen and we'll kick this off. All right, there we go. So my talk's going to be about issues with directors' remuneration, DLAs, dividends, and the recent cases of Ree Jones and Chalcot Training. So in short, we only have limited time this morning, so this is not intended as a complete in-depth delving of the topic, if we don't have enough time. But we're going to look at some of those issues that those of us in the junior end of the profession do come across quite regularly, and specifically issues related to remuneration and DLAs. I should say I've had about 5 cases come across my desk in the last few months, all involving some of the issues that we're going to speak about today. So this is very much something which some of you might be seeing, you might have seen it, and I would expect you to see it in the future, especially as we all know, the economy is in an interesting position at the moment, and going forward, there's serious risk to smaller companies. And what might happen if they go bust is we'll be investigating what some of the company directors and shareholders have done with funds of those companies. These matters, as I've kind of noted in my notes, might only amount to a few tens of thousands or hundreds of thousands of pounds. And so our more estimable, experienced senior members of our chambers and our firms might be more focused on some of the large insolvencies and restructurings. And these are the sorts of things that we might be focusing on more by ourselves, and more junior members of firms might be looking at by themselves. So this is quite useful to go through this, and I thought just to look at some of the basics of how to investigate some of these matters. I've gone backwards there. So what are we talking about? What is the intention of talking today? We're going to talk about directors' loans and dividends and remuneration. And specifically, we're going to talk about a tax avoidance / efficiency scheme, which I said I've come across quite a few times, which has been in the recent case reports. Now, the way this basically works, and some of you, this might be old hat for a lot of you, but the way it works is a director shareholder in a small company will often pay themselves a very small salary, say £1,000 per month, to the point that they don't actually reach their or exceed their personal allowance for income tax. Now, on top of that, they'll start drawing substantial amounts of money out monthly, and they'll credit that against their director's loan account. Now, what that does is it actually lets them take out monthly a substantial amount of money, but they're only actually having to incur PAYE and national insurance commitments to a relatively small amount of that. Now, at the end of the year, as this is a director's loan, ostensibly these individuals have a significant debt that they owe to the company. So I've used the instance of someone drawing £5,000 per month. At the end of the year, they might owe £60,000 on a DLA if they had not owed anything from a previous year and had they not paid anything back. What often then happens is if the company is in profit, these director shareholders will declare a dividend. Often they'll try to declare it for the exact amount that they've taken out of the DLA, and they'll offset that debt against the dividend. So in essence, they won't be taking more money out of the company, they'll just be legitimizing the funds that they have withdrawn. That wipes out the debt that they owe to the company, and as they've now received it as a dividend, they'll be paying a lower rate of tax than they otherwise would if it was straight salary. I don't know how much people have covered taxation on dividends as opposed to salary, but it's lower rates depending on how much you've taken out and what your personal tax band might be. I like to avoid tax as much as possible, so we're not going to go in depth into actual tax rates at the moment or the mechanics of that. But when do things go wrong? Well, obviously things go wrong at the end of the year if the company doesn't have distributable profits. So if it cannot declare a dividend, then that DLA will remain. Again, a lot of you probably know a lot of this, but I've just set out some of the basic laws on how one can actually distribute profits from a company. It's all set out in the Companies Act, but in essence, there must be distributable profits from which the company can declare a dividend for shareholders. If there are not sufficient profits, then any funds which are paid out ostensibly as dividends can be clawed back from their shareholders. There's a little more tricky than that, in the sense that the shareholders must have known or had reasonable grounds to believe that there were not distributable profits, and there's been quite a lot of case law recently as to when these might be declared, and what defenses a shareholder might have, and I've cited the cases of BTI, Sequana, and Burden Holdens at the bottom of this slide. I'm not going to go into them because, again, way too complex from my head at 11 o'clock in the morning and take us away from the main issue. But what happens next? Well, say that there are no distributable profits, a dividend is not declared, and the company is owed this debt from the director. Well, the company can simply demand repayment of the DLA. For whatever reason, the director falls out with the other directors of the company. Or the company might go bust, which is highly likely to happen. It's happened in a number of the cases I'm currently dealing with, in which case the liquidator takes over, sees this nice juicy DLA owed to the company and says, I'll have that asset, please pay it back. It's important to remember that DLAs are bare loans, interest-free loans. And so all that is necessary, but is a requirement, is that the company must demand repayment of that loan clearly and unequivocally. I won't go into the case law on demanding bare loans, but there must be a specific demand for repayment. It's not enough then just to simply go off and prosecute the matter or send a stat demand. Well, cue legal battles when that happens. So what often happens is a liquidator or a company says, all right, you owe us the DLA, we'll have that back, please. We need to use that money for something. And the director will say, whoa, whoa, whoa. We all know what this actually was. Yes, it's technically a director's loan account, but this is remuneration, or this is a dividend, a benefit in kind. It's something other than an actual loan. I know how it's recorded, but that's not what it is in substance. Alternatively, if the company's gone bust, what they might have done right before the company going into liquidation is they might have somehow tried to waive any DLA debts, or they might claim after the fact that they have done so. Now, that would obviously raise some of these statutory office holder claims, such as a TUV, if they're waiving it without consideration. We're not going to get into that today. We're just going to look at the mechanics of DLAs themselves. So you get these legal battles going on then. So where do we look to actually determine whether a director's loan account is actually a director's loan, or if it might be remuneration just under a different title, and whether a court's going to back us up or not? Well, obviously the place to start where everyone's going to look is the actual accounting records of the company. And most companies we deal with often run off Sage platforms, so you have a very specific accounting record of monies which are paid. Often there's a reference against any payment which is made out to a director. Often that reference says something like DLA loan, something to that effect. The same with company bank account records. So you can actually go through and look at every payment coming out of the company's bank account at RBS or wherever to try to find out what references are used. Especially in small companies where they don't necessarily keep the best accounting records, this sometimes can be a very time-intensive, but very fruitful form of investigation, as you are essentially recreating what the accounts of the company might have been. Look at the management accounts. Now, the management accounts might give you a little more detail of what the managers, the directors were actually doing. They weren't necessarily going into the statutory accounts because they haven't prepared them, but might have been on the way of preparing the stat accounts. Now, the actual statutory accounts themselves are incredibly useful, incredibly boring sometimes to trawl through, but they're all publicly accessible on Companies House on the beta platform. And in the notes of those accounts, if it's been done properly, and often these schemes involving DLAs and dividends have been done under the auspices of tax advice from accountants or tax advisors. This is a common advice that I've seen from a number of accountants giving to directors, is that the notes of these accounts will actually note how much a director owes to the company under a DLA. And it will likewise put under a section at the very end of those accounts, transactions with connected persons. Again, it will often note how much money has gone out to directors, and sometimes it might be particularized as to individual directors as well. Incredibly useful when that happens. But by far the most important and interesting thing to look at that a lot of people overlook is the company's corporate tax returns themselves. These are the CT 600 forms and CT 600A forms. Incredibly boring to be talking about corporation tax returns, but they are remarkably useful and remarkably overlooked in a lot of litigation. The great thing about these forms is that if there's a DLA of over £5,000, and if the company has five or fewer participators, which would be individuals involved with shareholding, then on a form called the CT 600A, the company must note how many loans are outstanding to individual directors and any loans which have been repaid by those directors. That information then gets funneled into the CT 600. So you've got, and then both of those, well, the CT 600 is then signed with a declaration, often by the director, noting that any false information might be the subject of prosecution. So what you then have is you have a very clear corporate tax return, often indicating the exact amounts which are outstanding on DLAs. And again, if these are prepared by professional accountants who have advised that this is a good tax efficiency scheme, this will be often will be included in all of these forms and might be overlooked in the initial investigations. But what's great about it is the signatures of the directors are on these documents themselves. So you have their own signatures admitting that they are DLAs owed to them, or owed by them to the company. Incredibly useful when it comes to cross-examination or trying to found a case. Which takes us to our first case of the morning, which is Re Jones, a recent case in the High Court, which was decided back on the 7th of May. In short, I've put up some of the basics, but there's a dispute between joint directors, shareholders, small company owned by two people, uneven shareholding of 65 and 35%. The individuals drew small salaries of £1,000 a month, but they also took DLAs of £8,250 per month. And at the end of the year, as I've said in this tax efficiency wheeze, they declared a dividend, wiped out any DLAs they owed. Now, as often happens in small companies, the director shareholders got into disputes with each other. The primary shareholder stopped any dividends being declared, and the company issued, well, initially he stopped any dividends being declared. The minority shareholder, I said S, but it's really the minority shareholder, issued a 994 petition for unfair prejudice, at which point the majority shareholder and director then had the company issue a stat demand trying to claw back the DLA payments owed by the minority director, potentially, as you'll see, improper in trying to frustrate the 994 petition. Initially, this was set aside in the county court. The stat demand was set aside in the county court by Deputy District Judge on the grounds that the minority shareholder said, well, hold on, amongst other things, this is remuneration. You can see the regular payments coming out. We agreed this is remuneration. It's just a tax efficiency matter. They're not DLAs, they're not dividends. And the Deputy District Judge said, well, there's a generally triable issue here, so we'll set aside the stat demand for, amongst other reasons. Appeal to the High Court. And it come before Mr. Justice Snowden. Amongst other things, I've just cited one paragraph of his judgment, but what he notes is, in light of the manner in which such arrangements are presented to HMRC, because what happened here was, as I've noted, there were CT 600 and CT 600A forms. Those have been signed. Those included various declarations as to the substance of these payments and the taxes that arose thereof. In general terms, I do not consider that such periodic drawings can simply be recharacterized as remuneration, as and when it might suit one of the recipients so to contend, or at least that cannot be done without acknowledging that the manner in which they had previously been disclosed to HMRC had been incorrect, with all the consequences in terms of the payment of additional tax, interest, and penalties this might entail. Now, obviously, that what he's alluding to there is there would obviously be increased tax for the individual director if he now claims the remuneration. But additionally, as we raised, there's also the subject possibility of prosecution of the individual for tax evasion. If they're now claiming in court that it's remuneration, and previously they've signed their tax return saying that it wasn't remuneration, knowing that they might face prosecution. There's at least a decent potential that HMRC could say you're trying to evade tax, lying to us, and we're going to come after you. No one really wants to be in that bind. A useful bit of litigation, though, tactic if you are on the other side of this. So ultimately, what Snowden did is he actually upheld the judgment at first instance. He said the judge was wrong in regards to a generally triable issue as to the nature of the remuneration, but because this was being used as a means of trying, the stat demand was being used as a means of trying to frustrate the 994 petition. This is an improper use of insolvency proceedings, a bit of old law there that we're not going to go into too much depth, but don't use bankruptcy proceedings to try to frustrate other proceedings. The courts do not look kindly on such attempts. So I've just summarized some of the takeaways there. But the big thing, as I said, is to look beyond the basic issues that people look at of emails and maybe even just bank records or company accounts, to actually look at the corporation tax returns. And if you can get them in disclosure, look at the individual's personal tax returns if they filed them as well, because again, they might be declaring what they at the time considered those payments to be, whether it was remuneration or something else. Or if there's an absence of any declaration on these things, or a declaration that they're dividend payments, then you've got them nailed to the wall on their personal tax return as well. But is that all you need? Is there anything beyond the papers that is necessary to consider? Well, cue the case of Chalcot Training and Ralph, which was decided 2 days before, or was published 2 days before. Reed Jones was, again, considering issues of directors' remuneration. The text on this is much smaller and much more detailed, but in essence, it was a very complex tax avoidance scheme. 2 director shareholders of the company set up an LLP, which they themselves were members of, along with the company, traded through the LLP. All the profits of the LLP went back to the company, where they could be taxed at the lower corporation tax rate. The company would then make those payments to the 2 directors, but required those 2 directors then to subscribe for shares to the company. So the payments were ostensibly remuneration and deductible for corporation tax purposes, but the requirement to subscribe to the shares meant they were not subject to income tax or national insurance because they did not constitute taxable earnings. So essentially the 2 leveled out. These are the kind of schemes I don't like getting involved with. But quite interestingly here, we had a reversal of the normal position. So in this case, what HMRC actually did is they piped in and they said, well, whoa, actually, these payments are remuneration and they should be attracted income tax and national insurance contributions. In this case, then the company, through its directors, said, well, actually, no, it's not remuneration, hold on. They're actually unlawful distributions of profits, and so the money just needs to come back to the company, and there's no tax payable by anyone on this. HMRC opposed that application, and as I said, I argued that they were remuneration. So what's useful in this is the judge in this, Michael Green QC, is laid out a more involved test than Snowden did, is to actually look to see how a court might determine the issues on payments where someone is trying to recharacterize remuneration as a distribution to shareholders. In this, he went through a lot of past case law, which I'm not going to delve into because I know I'm running slightly low on time and we need to get to Jonathan's talk in a second. But it's not a purely objective test. There are subjective states of minds of those deciding on the transactions, and you need to look at that to see what the true purpose and substance of the impugned transaction might be. But as we've covered before, the way those parties have described that transaction on documents and other documents can be relevant facts. I'll let you read that all later. But what happened here was, to avoid the corporation tax, the payments had to be, by their nature, allowable expenses. Just a bit of tax law there, which is employment related. Even if not strictly remuneration. So the individuals were receiving these funds in their capacity as director employees, not as shareholders. The documents for the scheme itself, and this is something to look at if it's a formal scheme which has been advised by tax advisors, they will actually describe often in those documents how the payments were being characterized. Here, they were being characterized as payments for employees from an employer, and as part of employment arrangements. The statutory accounts describe the payments as remuneration. As I noted earlier, looked at the statutory accounts. There will usually be a specific section for direct remuneration. And ultimately, the scheme would only work if they were payments to employees. Otherwise, the tax relief would simply fall apart. So on the facts, in this case, it was the reverse, where it was clear that these payments were remuneration. So what are our final things to draw from all of these various boring discussions of CT 600 statutory accounts in these cases involving tax avoidance schemes? Dig deep into the documents to see how the payments have been characterized themselves. Don't just look on a cursory examination necessarily of the SAGE, start there obviously, but then look to see if there's been advice from accountants, how it's been advised, look to see the corporate tax returns. And look at the capacity of the person who's actually receiving it, or how they're receiving it. Are they receiving it for work as a director, or could it be disguised as an interim dividend? So anyway, that was a whistle-stop tour through these two cases and director remuneration. With that, I say any questions. We'll have questions at the end, I think. And at the moment, we should now turn to Jonathan for his talk. So I will...
So I'm going to talk about two topics which aren't obviously related, but there was a connection between them in a recent case. And those are how partnerships work when either the partnership or one of the partners or both has become insolvent, and the separate issue of the bankrupt's or someone close to the bankrupt's home revesting in them automatically if the trustee hasn't done anything with it within 3 years. And those are the three topics I'm going to cover. So I just said the partnership property issues, how it relates specifically to the revesting of the home, and then also a slightly different topic, how the revesting of the home works, where the person doesn't actually own the home, but they have a proprietary Estoppel claim to it, which I think is a fairly new issue, but it did arise in this recent case, which is called Break and Swift. I don't know if any of you have been following this. It's been producing a ludicrous number of judgments published on Bailey. So clearly very hard fought. Don't quite know where the former bankrupts are getting their funding from, but they're certainly exploring a range of legal issues. And the judgment I'm going to be focusing on, which prompted the subjects for this talk, is the one given very recently in July 2020, which dealt with a number of the substantive issues in dispute, although not all of them. And what it boils down to is what the parties were interested in was whether a cottage and some bits of nearby land had revested in the two bankrupts automatically after 3 years. And one of the requirements for that is it's got to be their only or principal residence. And in the end, what happened is that on a factual inquiry, it was held that that was not satisfied. And so regardless of everything else, their argument couldn't have succeeded because of that. There's nothing new there. It's always going to depend on an assessment of the facts. But on the way to that conclusion, the judge did also decide a number of other issues, which I think are less specific to that case and could be more general. Have to start with, because what I think caused a problem for the bankrupts in that case was they either didn't focus clearly enough on the nature of partnership and partnership property, or more likely, I think, their lawyers did appreciate it, but were trying to fudge the correct analysis and find a way around it. I think it's unlikely they overlooked it altogether, but anyway. It's important to be clear what we're talking about. I'm going to focus entirely in this talk on partnerships under the Partnership Act 1890, which are the basic kind of partnership. You could have that kind of partnership before 1890, but that legislation codified many of the existing principles. And the nature of such a partnership is it's not a legal entity like a company. It's just a group of people. The group can change from time to time. They're usually flesh and blood human beings, but they don't have to be. And what makes them partners is they carry on business together with a view to a profit, and they one of the most important features of that is they can all bind the firm, and they can all have personal liability for all the debts of the firm, even if it's a bit of the firm that they weren't personally involved in. It used to be the case that all solicitors had to trade as an unlimited partnership of this kind. It's not been that way for quite a number of years. But certainly must have been a good number of solicitors who founded on this principle when partners in other departments of the firm had catastrophic problems which resulted in the firm going bust. And that would have had unlimited negative financial consequences for all the other partners, even if it wasn't their fault. There was a slight change to this, or there was a variation introduced by Limited Partnership Act of 1907. You don't see very many of these, but they are around. They're based on the normal kind of partnership, but they have a couple of extra features. Basically, you can have general partners who have unlimited liability, but you can also have limited partners who are only in for a certain amount of money. But the quid pro quo is that they also have much less involvement in the business and much fewer rights. You don't see very many of those. I'm not going to be talking about them. Something else I'm not going to be talking about is LLPs. Although they're called partnerships, they actually work in a very different way. Unlike partnerships, which are just groups of people, they are legal entities in themselves. And mainly, the provisions of the 2000 Act are pretty similar to legislation that relates to companies. So, although people often talk about partnership in a way which encompasses any of these, we're going to be focusing on partnerships under the Partnership Act 1890. It's important to be clear about who's become insolvent and what assets are relevant. So it's certainly possible for one of the partners in the partnership to become insolvent, but the partnership itself being fine. And that's because, of course, the partners have their own lives independently. Well, they do if they're flesh and blood human beings anyway. And they might have completely unrelated debts, and they might be made bankrupt because of that. That doesn't necessarily bring the partnership to an end, although, in fact, if there's no agreement about when the partnership will come to an end and when not, the default position is that bankruptcy of a partner will dissolve the partnership. But that doesn't necessarily have to happen. Now, if we're talking in the abstract, because all the partners have unlimited liability, and because the partnership is just a group of people, in a way, you can't have a partnership which is insolvent unless all the partners are also personally insolvent. And that's because with unlimited liability, whatever the debts of the firm are, they will have recourse to all the partners' personal assets, even if not used in the business, if need be. But this is quite an abstract way of thinking about it. So although sometimes it does work out that way, with the partnership being wound up and all the partners being made bankrupt pretty much at the same time, it doesn't have to, because the insolvency processes don't just follow what everyone's liabilities in theory are. Someone has to initiate the process, and it's absolutely possible to have a partnership wound up because it's run out of money, basically, without all the partners individually being made bankrupt. That can develop over time, but you've got to pay attention to what has actually happened, what processes have been initiated. It's not as simple as looking at what the liability is in principle. There is legislation on this. The main bit you need to know is the Insolvent Partnerships Order 1994. I say you need to know it's there. It's actually incredibly difficult to understand because the way it works is it is based on other legislation, particularly company legislation, but it modifies it in quite a lot of ways. So some provisions don't apply, various defined terms are changed. So it's really quite difficult to understand. And when you have a particular issue, you need to sort of tackle it afresh and work out what exactly the law says. And as one of the leading textbooks on partnership comments, what this leaves us with is an indigestible patchwork of provisions, which I think anyone who looks at it could agree with. So leaving aside the really complex detail of the legislation, I've tried to summarize what some of the basic principles which you need to have a grasp of generally. And the starting point is, you could be aware that some assets are partnership property and some aren't, that they are owned by people who are partners, but they're not part of the partnership. And it's not always obvious which assets are in which category, because even if you've got a firm which is trading from business premises, it might look like that's owned by a partner and therefore partnership property, but it could be that it's owned by one of the partners personally outside the partnership, and they're just letting the other partners use it as well. That's possible. And in that case, the business premises won't themselves be partnership property. So you can't make any very ready assumptions. You have to analyse it. But whatever the partnership property is, and whoever's name it's in, it's held on trust, and that's provided for by the legislation. And so in a sense, once you've decided it's partnership property, it doesn't really matter who the legal owner is. And partners in partnership disputes often don't understand that, because when they've fallen out, they start looking at what assets are in their name, and they want to keep those all for themselves. But in many ways, that doesn't really matter, because all the partnership property is held on trust for the partnership as a whole. And because it's trust property, it doesn't vest in the trustee in bankruptcy either. What is the trust then? Well, another common misconception is that if you've got a very simple partnership with two partners and they each share all the profits 50-50, they might think that everything which is partnership property, so if they've got one office in London and one in Glasgow, they might think they own 50% of the London one and 50% of the Glasgow one each. And the same with every other asset. They think you can split every asset down the middle. That's not the case at all. Their entitlement is something quite a lot more nebulous than that. The detailed provisions for an accounting process which has to be gone through before you can really know what each partner's interest is. And hopefully they have good accounts that they've been keeping as they go along, but they might not do. And to find out what the accounting process is, you have to look at the Partnership Act. One thing that's worth bearing in mind is even if you're a 50-50 partnership, it's not necessarily the case that your share in the partnership is worth something, even if the partnership as a whole has more assets than it has debts. And that's because the partners are also accountable to each other. You might have one partner who put in a lot more capital, and although the partnership has net assets, it has fewer net assets than that partner's capital contribution. And in that case, the partner who didn't contribute is actually liable to make up part of the shortfall. So it's not necessarily the case that even a partnership business which is solvent is an asset as far as each partner is concerned. There's really no getting away around the fact that you need to do the full accounting process before you can be sure what each partner is entitled to. This sort of collection of rights and liabilities is often referred to generically as a partnership share. And if a partner is made bankrupt, the trustee in bankruptcy will stand in their shoes, basically. So the partnership property doesn't vest in the trustee in bankruptcy, but the right to have this accounting process carried out does. So if the partnership share is worth something, then the trustee in bankruptcy can try to realise that by bringing about the accounting process and dividing up all the partnership assets according to what the result of that process is. And if the partner actually owes money to the other partners, for instance, then that will be a liability of the bankruptcy estate. But you have to go through the partnership, if that makes sense. You can't just look directly at what the assets are. So that doesn't have any obvious connection with the revesting of the bankrupt's home, but it did in Brake and Swift. And to show why, we've got to first of all look at what the revesting provision is. You'll come across this very often. It's routine, because most of the time where a bankrupt owns their home, one of the main tasks for the trustee in bankruptcy will be to see whether there's equity in there that they can realise. And these days, they've only got a limited amount of time to do that. And that's because of section 283A, subsection 1, which I've typed out there for you. Gist of it is, after a certain amount of time, 3 years from bankruptcy, if various steps haven't been taken, the most usual one is applying to sell the property. Then, if it's a property which is a dwelling house lived in by one of these people as their sole or principal residence, then it will automatically go back to the bankrupt. And because it happens automatically, you can often have disputes after the fact about whether it's happened or not. And that was the case in Brake and Swift. But that's the provision we're interested in. And you'll see that, as I mentioned earlier, where the people in Brake and Swift came really unstuck was the sole or principal residence test. But there are other questions as well. So one situation that can arise is where people are living in a house, but the house isn't owned personally by them, just in the way that most people own their homes. It's actually partnership property. It's being contributed as an asset of the partnership. There are a few situations where that is quite common. Often the case with farming businesses. The farmhouse will often be partnership property. It could happen with pubs, things of that kind. Situations where you've got a single lease of a shop and a flat above is another category. There aren't limited categories, but those are the kinds of situations where it will be common. So what then? Does that count as an interest in the dwelling house for section 283A, so that if it's not realised for a certain amount of time, it will go back to the bankrupt? Well, if it's in the bankrupt's name, that doesn't matter. That doesn't help the bankrupt, because if it's partnership property, it's held on trust for all the partners. So it doesn't even vest in the trustee in bankruptcy in the first place, so it can't revest. What about a claim to a beneficial share in the property? This goes back to the common misconception that if the partners have been sharing all the profits 50-50, they can also split all the assets down the middle as well. The answer to that is no. Applying the orthodox principles of partnership, they don't have a specific share of each asset. What they have is this less clear right to have the accounting process done and to have whatever the outcome of that is. So that was held in Brake and Swift. What about the partnership share itself? Could that help the bankrupt? Well, the partnership share, which is the partner's rights to have this accounting process carried out, that does go to the trustee in bankruptcy, so it does vest in them. And so, in theory, it could revest. It didn't help in Brake and Swift because it wasn't just the individual bankruptcy of the partners. The partnership itself was insolvent. So there wasn't anything that was going to come out at the end of the accounting process, because before anything would have been distributed to the partners, it would all have gone to the creditors of the partnership. So there was nothing left over. What Brake and Swift didn't consider was what the situation might have been if the facts were different. What if, although one of the partners is insolvent, the partner who's living in the house, which is partnership property, the partnership as a whole is solvent and has net assets? I think the answer to this probably depends on how exactly the partnership is wound up. Your starting point is what happens is all the partnership assets are sold, and then so they're converted into money, and then you work out, after paying off all the creditors of the partnership, what each partner is entitled to. Some might be entitled to more than others. But if the bankrupt gets a sum of money, then that's not an interest in a home, I don't think. So I don't think there's anything that could revest. But the court doesn't have to wind up the partnership in that way. It has other options. So sometimes what you get in a winding up of a partnership which is worth something is that rather than having every asset sold, the court will try and work out some assets going to one partner and some going to the other. So that's called an in specie distribution, because the assets themselves are just transferred to the partners personally. Now, if that happens, and if the bankrupt is distributed, or the trustee in bankruptcy has distributed a share in the house or the house outright, then it seems to me there's quite a good argument that that could revest after 3 years. But I wouldn't get my hopes up if I were bankrupt in that situation, because it's the trustee in bankruptcy who will be deciding what the arguments in the winding up process should be. And if they're awake, they're not going to be letting it be done in such a way that the house will leave the bankruptcy estate altogether. They'll be trying to realise it for creditors. So I think that's probably a theoretical possibility. So the brief takeaway is that just because you're a 50-50 partner, doesn't mean that you've got a 50% share in a property, which can be affected by Section 283A and might revest in you. It's less easy for the partners than that. Something quite different. This was an alternative line of argument they tried in Brake and Swift. They said, well, although it looks like partnership property, we actually think we've got a proprietary estoppel claim, so that we should be entitled to this cottage personally ourselves, because there was a representation or a promise and we relied on it. And what the judge held was that a claim under proprietary estoppel, even before it's been decided by the court, is a property interest. And part of the reasoning for that is because it can bind third parties. And then he asks, does it form part of the bankruptcy estate in the first place? And the answer to that is yes, it does, because almost any kind of property will vest in the trustee in bankruptcy. Not quite everything, but certainly most things. And a proprietary estoppel claim does. There's no particular reason why it wouldn't. And the judge also held that there was nothing special about the provision in Section 283A, which meant that it was relevant only to a smaller category of kinds of property. So he held that, in theory, if the bankrupt is living in a house and their only claim to that house is a proprietary estoppel claim, and the trustee in bankruptcy doesn't do anything about it, then the proprietary estoppel claim could go back to the bankrupt. I think one of the arguments the trustee was trying to rely on was that it's one thing trying to sell a house, but trying to sell a proprietary estoppel claim is very, very difficult. The judge wasn't impressed by that. And I think part of the reasoning was that he reasoned you could sell it to the legal owner of the house, who will want to get rid of the proprietary estoppel claim perhaps, or you can sell it to the bankrupt's individual or family member or something like that. So although there's no general market for proprietary estoppel claims, it is possible to realise them. And the other thing the trustee in bankruptcy could do is try to litigate the proprietary estoppel claim and either win or get a settlement. But because it's bankruptcy, there's usually not a lot of available cash. That might be quite difficult. So the bankrupts in Brake and Swift did actually get somewhere with the proprietary estoppel argument. It failed in the end because the property in question was held not to be their sole or principal residence anyway. So Section 283A was of no application. But in a fairly uncommon but not unknown situation where the bankrupt has a proprietary estoppel claim, it seems like it could revest. So that's something you want to be aware of if your client is a bankrupt or a former bankrupt, and especially perhaps if you're a trustee, because you need to be doing something to realise your interest. Otherwise, it might go back to the bankrupt. You can't just leave it. So those were some of the issues covered in Brake and Swift. There were lots more. There are a lot of judgments in the case. Most of them were worth reading. But those are some issues which show how the perhaps not very well understood issues of partnership and proprietary estoppel can be relevant where a partner becomes bankrupt, and particularly relevant where they're living in an asset, which is partnership property or business property. Okay, so those were all the points I wanted to make about that case. I think we'll have questions now if there are any, but thank you for listening. Unless you have any questions, Andrew.
I always have questions for you, Jonathan, because you're my go-to source for all in-depth insolvency matters. But here's a basic question. If you're dealing with a partnership and potentially looking into some of the issues you've talked about, basic question, will partnerships have specific accounts as to what's going on within them? Will they have something akin to what a company is doing?
Well, they ought to. It would be a good idea, particularly if the partnerships affairs are complicated. But no, they don't have to. And also, they quite often don't, because people sort of accidentally get into partnerships. They want to start up a business venture with someone else, so they do. And for instance, I was involved in one case where it was two young people setting up, I think it was a hot dog or burger van. And so they each chipped in some of the equipment and started going to places where they thought they might be able to sell their products. But they hadn't really given much thought to the fact that they were entering into a partnership. And they certainly didn't start drawing up sophisticated accounts. But so you can get accidental cases. But hopefully there'll be partnership accounts, particularly if it's a firm of any significance. I think probably the situation where you get lots of assets but terrible accounts is most common farming. Because very often the farm just continues quite happily for years or decades, with everyone sort of understanding what their expectations are, but then something happens to cause a falling out, and then they look at the accounts afresh, and all these things which they've not really been given any thought to that were in the accounts suddenly start causing problems, because the accounts don't really reflect what was happening on what everyone thought the position was. So as with other areas of law, farms often give rise to difficult cases.
Well, right. In which case, I think that might conclude our session, unless you have any questions for me, Jonathan.
I think I'll let you off this time, Andrew.
Oh, thank God. Lovely. In which case, thank you all for coming. Thank you all for attending. If you have any specific questions, feel free to email us, or perhaps I shouldn't speak for Jonathan. Feel free to email me directly.
Yes, please do.
Including any, and do give us a shout if we can help with anything in the future. Thanks for coming this morning, and have a lovely day, everyone.
Yeah, thanks everyone.